Hello and welcome back to this third section of the CPD seminar on personal searching. This section is going to look at the liability of searchers and how that changed following the 2007 Act, and we'll also then have a look at searching practice. So the case I'm going to speak about in just a minute involves the property at 6 Arbroath Place, Arbroath, and hopefully 6 Arbroath Place, Arbroath appears on the picture behind us on the left hand side. Google Street View rather let me down here. It's only going to the end of the cul-de-sac and doesn't go down the road. So this is taken from the end of the road. The case that I want to have a look at is Commodity Solutions Limited and the liquidator thereof against First Scottish Searching Limited, and it's reported at various points. So 2018 Sheriff Court Dunfermline at 14 for the first instance decision at debate, 2019 Sheriff Appeal Court Civil at 4 in respect of the appeal in that debate stage, and now 2020 Sheriff Court Dunfermline 29 after proof. The facts were remarkably similar to those in the Tinsley litigation. Here the inhibited party had been a company director, the company had gone into liquidation, and the liquidator had raised proceedings for £50,000 against the inhibitee in respect of monies extracted from the company. He obtained an inhibition, and the inhibition is at the correct address, 6 Arbroath Place, Arbroath, and in the correct name. So in that sense it is distinguished and distinguishable from the Tinsley decision. The other difficulty presented in the instant case was in relation to the sale of the property. In this case, the inhibition was against a father who, and not his wife, but the father and mother, sold the property to son and daughter-in-law for value. So it's almost identical, but not quite. There are a couple of preliminary questions to look at, preliminary questions of law. First of all, were negligent searchers now liable after the 2007 Act not to purchasers who relied on the information supplied in their reports, but to the creditor who is disappointed by his inability to enforce an inhibition and receive payment from a dealing of the property? The factual questions that need to be addressed in the circumstances were the son and daughter-in-law unaware of the inhibition against the father. It's one thing to be aware of the company failure, but it's quite another to be aware of the existence of an inhibition. And the second question that needs to be posed is, were the disponees for value therefore falling within the terms of section 146 of the Bankruptcy and Diligence Act 2007? And we need to examine a little bit about the history of the transaction. The property had been on sale previously for a significantly higher amount, but there had been no interest in the property. It was then remarketed maybe 9 months or a year later at a lower price. An offer was received, but the transaction never progressed. And at that stage, the son and daughter-in-law stepped in, buying it for £1,000 or £2 less than the offer that had recently been received. So, was that for value? Oddly, in the three decisions that I've referred you to in the Commodity Solutions case, there is no reference to the work of the Scottish Law Commission, which resulted in the passage of the Bankruptcy and Diligence Act. So the courts addressed the matter from first principles. Now, in fact, there is nothing in the report from the Scottish Law Commission on diligence in relation to liability of searchers to disappointed creditors. But in the antecedent discussion paper, the Law Commission had asked consultees the specific question: should provision be made in the legislation for liability of searchers in just these circumstances? For some reason, this question is not taken up and addressed in the final report, and therefore doesn't appear in that report, nor in the draft bill, nor in the Act, 2007 Act that implements that report. So it's clear from taking up the matter as a point for consultation that the Law Commission thought that it was appropriate to make searchers liable where the inhibition was not detected, and the creditor was thus unable to enforce their inhibition, the purchaser taking free of the inhibition, satisfying the requirements of section 146 of being in good faith and for value. In the Commodity Solutions case, of course, there is a heritable security granted by the son and daughter-in-law, and clearly these parties, or the creditor party, was completely unaware of the existence of the inhibition. So when we look at the court, or the Sheriff Appeal Court decision, working out whether or not there ought to be liability in such circumstances, as I've said, this was deduced from first principles. And Sheriff Principal Pyle said in paragraph 47, in summary, where the task of searching has been undertaken voluntarily, for profit, in circumstances where the economic well-being of inhibiting creditors is known to be dependent on searches being carried out with care, in my view, it is just and reasonable, third limb of Caparo, that a duty of reasonable care is incumbent on the searcher. So the searchers in this case were liable. If I say just a little bit in this section now on searching practice, we note that inhibitions prescribe after 5 years. That period was brought down from 20 years by the Conveyancing Scotland Act 1924 with effect from 1930. Gretton, in his book in the 1980s, said that the right to reduce is based on the existence of the inhibition, and that right to reduce a subsequent transaction is a right in relation to heritable property, and therefore that right subsists for 40 years after some act in breach of the inhibition. So that would suggest that the period we need to search is actually much longer. It's also necessary to have a look at other things that can appear in the personal register, such as sequestration, and here the debtor is automatically discharged, and that can be extended, deferral of his discharge can be extended for a further period. That, however, does not reinvest the debtor in the property. So we need to search back 5 years because all entries in the personal register will expire after 5 years. MacDonald, in the 5th edition of his conveyancing manual, said 5 years back from the current date against all parties having an interest in the prescriptive period. Reed and Gretton in conveyancing say and have always said all parties having an interest in the prescriptive period for 5 years prior to their disposal. But entries subsist, and the matter is put beyond any doubt by the provisions of the Bankruptcy and Diligence Act, which were brought in to remove any doubt. One question that occurs is, if an inhibition only affects future acts which are to the prejudice of a creditor, do we need to search against a purchaser as well as the seller? So in the reports that are obtained at the start of a conveyancing transaction nowadays, we won't have the purchaser's name because we won't know who the purchaser is in most cases. So we need to have a further report including the purchaser's name. Is that strictly required? In Leeds Permanent Building Society against Aiken, Malone and Mackay, that question was asked. The purchaser defaulted on the loan. The heritable security in favour of Leeds Permanent Building Society was called up. Leeds entered into missives to sell the property, but the purchaser refused to settle on the basis that the purchaser had been inhibited and that hadn't been picked up by the solicitors. The solicitors argued that it had no adverse impact on the transaction and therefore it should have settled and no course of action was held to lie against the solicitors. So if we looked at that case alone, it would suggest we don't need to search against a purchaser. Alliance and Leicester Building Society against Murray's trustee and Royal Bank against McGregor. McGregor was also the trustee of Murray in the earlier case, give conflicting views as to whether or not a transaction by the debtor is caught. In Alliance and Leicester against Murray's trustee, Murray was sequestrated between the obtaining of an interim report and the settlement of the transaction. It was held that the property fell into the sequestration and Alliance and Leicester were left with a post-sequestration debt and ranked dead last rather than first charge over the property. In Royal Bank against McGregor, which appears to be a 100% mortgage case, very similar set of circumstances, it was held that Royal Bank would be preferred and that the trustee could not rely on the fraud of the debtor in applying for the loan, saying that they had never been subject to sequestration and they'd only been sequestrated about 18 months previously. Thus, the trustee was unable to benefit from that. There must be a question, however, as to whether or not that case is wrongly decided. But it's very clear from these cases at common law that there is a requirement to include a purchaser in the search. The matter is free from any doubt whatsoever in the UK Finance Solicitors Handbook, formerly the Building Society Handbook, and before that, and Lender's Handbook in between times. But paragraph 5.3.3 provides you must ensure that any other usual and necessary searches which may be appropriate to a property are undertaken, and you must report any adverse entry to us. So clearly there is a duty to include a purchaser. Whether or not the creditor is adversely affected, they want to know. In relation to the land register in Halifax against Gorman, the search inexplicably did not include the inhibitions against Mrs. Gorman. Now, I actually did at the time a search against Mrs. Gorman at her former address. It threw up 10 inhibitions against her and her builder husband. So how searchers failed to obtain any of these inhibitions, it's not clear. The keeper registered the disposition in favour of the Gormans because that wasn't prejudicial, but they didn't include the standard security in favour of the Halifax. The Halifax raised action against the trustee, but it's not clear what the case would have resulted in had action been taken against the keeper at the Lands Tribunal in relation to the refusal to register. So that brings to an end this section of the seminar.